the session on Introduction to Labour Legislations. In this session, I am planning to cover the background of the labour legislations, the principles behind it, the industrial jurisprudence, and the labour laws and the constitution in an elaborate manner. First of all, let me take you through the background of the labour legislations. Every country has its own background and history behind the evolution of labour legislations. India is not an exception to this. We also went through a lot of necessities of evolution of labour legislations. As we know that in 1863, the activities of industrialization started, like tea gardens, and the factories were set up during the First World War, and a lot of activities started. In fact, the first Factories Act was enacted in the year 1981. Subsequently, it had to be amended because it did not meet the requirement of or the expectations of the workmen, and still they were underprivileged, and a lot of representations were made, and accordingly the act was modified in the year 1934 also. And subsequent to that, the legislations like Workmen Compensation Act in 1923, Mines Act in 1923, and Trade Unions Act in 1926, and followed by number of legislations. We can see all these labour legislations are oriented towards the providing better working conditions and to lessen the hardship of workmen and to avoid the exploitation of workmen. In order to ensure proper employer and employee relations, in fact, for the first time, the trade disputes in 1929, it came into being. But of course, this was not very much popular in the sense that the provisions were made in this act, the restraining the strike and lockout, but no machinery was provided to take care of the dispute. The basic objectives of these legislations were mainly focusing on avoidance of exploitations and bring some conditions of work in a regular manner. In India, all the legislation during the period and up to the date of independence had borrowed the concept from British jurisprudence. Now, the importance of labour relations are very much important here, play a very, very crucial role in the entire economy. In order to have a productive economy, it is very much essential that the individual productive and collective employment relationship are extremely important for a productive economy. By providing a framework with which employers and workers representatives can interact with regard to work-related issues in order to provide a workplace democracy, which is very much essential to maintain harmonious industrial relations. And the labour relations also provide a very, very clear and reminder and guarantee of fundamental principles and rights of work which have been broad social acceptance and establishes the process through which these principles and rights can be implemented and enforced. So from this point of view, the labour relations play an extremely important and crucial role. Hence, we can summarize the need for labour relations as follows. Necessity for health, safety and welfare of workers, necessity to protect the workers against oppressive terms as individual workers economically weak and has little bargaining power, to encourage and facilitate the workers in an organization and to deal with industrial disputes and to enforce social insurance and social welfare schemes. These are the need for labour relations in a summarized manner. The objectives are very clear. In short, it has got twofold. One is that the preservation of health, safety and welfare of the workers and maintenance of good relations between the employers and the employees. The principles of labour legislations. The important principle here is what we call social justice. The social justice, what it means that there shall be equality in terms of law, equal enforcement of fundamental rights guaranteed under the Constitution, and equality in terms of justice and equity, and to make a comfortable living for the workman, to ensure these are all the important aspects of social justice. This is the essence of democracy in India, so that the social justice is just assured to all sections of the community. Then it also should also provide the protection of those who cannot protect themselves. In modern industrial setup, workers left to themselves are unable to protect their interests. Hence, freedom of in association, the power of collective bargaining, and by providing for mediation and arbitration in case of industrial conflict. These are the main principles on which the entire social legislation have been built upon and practiced in India. The social equity, this is based on principles provided by achievement of different standards. Different standards in the meaning is that standards of living, comfortable standard of living, in terms of safety, in position in society, and in the working population. These standards for the working class can be achieved by bringing about changes in the law of our land. Power to change the law is exercised by the government. Existing labor laws may be amended to meet the changed standards, because we know that labor legislations are not static. It has to be changed in line with the social requirement, in line with the societal requirements. The second thing is important in the national economy. The growth of industry, satisfy the human and intellectual needs of citizens for the benefit of nation as a whole, and growth of industrial efficiency. This is extremely important. And also we have, it has got a responsibility towards international uniformity. In other words, the ILO conferences sets up many conventions to fall in line with the global standards, in line with the global standards for enforcing social equity. And from this point of view also, the legislation should aim at all these things. Social justice and the judiciary, how it is interconnected, this is very important and very interesting to go through that. In fact, the role of judiciary has been very significant in providing just social justice to the workers by eminent judges. To quote a few, Justice Krishna Iyer, in the case of Indian Express newspapers versus Indian Express newspaper employees union, said that, he said beautifully well as far as the social justice is concerned. He said that the industry jurisprudence is not static, is not rigid, and it is not textually cold, but it is very dynamic. So in other words, even though it is not mentioned in any book of law that the social justice, the industrial tribunals of India have to go by the constitutional mandate for social justice to claim the claims of the people. And this is an important aspect, an important message given by Justice Krishna Iyer in his judgment, and it can be pointed out here that every state has certain ideas and values to be followed, and they can be achieved through various legislations. I will just take you through some important opinions of various eminent judges in the country who are endorsed that the social justice is one of the most important issue in the labor legislations. As back as 1949, the federal court in the case of Western India Automobile Association has pointed out the interest of social justice with a view to securing peace and harmony between the employer and the workman in industrial adjudication, impose new obligation or abolish the old ones and bring a new one to suit the entire thing. And in fact, this opinion of the federal court also supported by subsequently by Supreme Court in Bharat Bank versus employees of Bharat Bank Limited and other subsequent cases. In the historical judgment of State of Bihar versus Kameshwar, Supreme Court has given below. He said that in the onward march of civilization, our notions as to the scope of general interest of the community are fast changing and widening, with the result that the old narrow notions as to the sanctity of the private interest of individual who can no longer stem forward, looking forward time, and necessarily give way to broader opinions, broader notions of general interest of community. These modern systems of social and political philosophy well reflected and given the expression of our constitution. In short, he emphasized the dependency on the Constitution, how important it is in going towards the social equity. Justice Bhagwati, another eminent judge of the Supreme Court, he said, in an exceptional case, about the notion of social justice have marked the ultimate object of industrial education is to true help towards growth and prosperity of a national economy and promote industrial peace. In fact, in 1957, in one of the Supreme Court cases, he came out with this. In fact, if you see, Justice Vittala observed that in the case of Ashti Mill Mazdoor Sabha and Apollo Mills case, he said the social justice is not based on contractual relations, but is to be enforced on principles of contract as service, but is something outside the principle and evolved to justice without a contract backing it. He said that it is not only the contract what it says the principle, but we have to go beyond that to provide the social justice in this case. And in fact, even Justice Gajendra Gadkar introduced very important philosophy that concept of industrialization is positive and postulate existence of understanding, cooperation and sense of partnership between employer and employees. He says that the state should try to avoid strikes and strife in the industrial world to maintain cordial and harmonious relationship between the labor and the management. This is in case of Standard Vacuum Refining Company in 1961. So here if you see that almost all these Supreme Court eminent judges have stressed upon the importance of social justice in the labor relations and the responsibility towards this. One of the important prominent Supreme Court judge, Mr. V.R. Krishna Iyer, has made a revolutionary and progressive philosophy in this direction. He has delivered any number of judgments in line with his thinking of developing a progressive philosophy towards the labor legislations. He said in this case, he mentioned that the human force or human factors or human beings cannot be treated as a cogs in the wheels of machinery. In other words, there should be an element of humanity, there should be an element of social justice, and the workers should have, they would like to have a responsible and respectable place in society and also in the industry where they work for next 100 years. This is how he emphasized in one of the judgments. Another important judgment in the matter of social justice, in the case of Board of Trustees versus the Port of Bombay versus Dilip Kumar 1983, Justice Bhagwati made a very, very important statement. He said, justice must not only be done, but must be seen to be done, is not a requirement of courts alone. He emphasized that it is the responsibility of all the people who are involved in implementing the principles of legislation, including social justice. It is a responsibility of everybody. It's a collective responsibility. It's not the question of saying only the court should say that this is the provision, but everybody who is responsible must go by this principle. It means the justice not only done, but it seems to be done. Now, this is about how the labor legislations developed in India, the main principles behind it, and how the philosophy has been inbuilt into the legislations. We'll go through one by one. Labor legislations broadly can be categorized under 4 categories. That one is, we can call it as regulatory, and another set of legislations welfare, and another set of legislations social security, and another set of legislation trade union and employee relations. And in regulatory relations, we have almost n number of regulations. To give an example of, let us say, Factories Act, it can be Commercial Establishment Act, Contract Labor Act, Minimum Wages Act, Payment of Wages Act, Payment of Bonus Act, Payment of Gratuity Act, Equal Remuneration Act, then Sexual Harassment of Women at Workplaces, Prevention and Redressal Act, Apprentice Act, Interstate Migration Work Act, and Building and Construction Workers Act. These are a few examples of regulatory legislations. As far as the welfare is concerned, we have Industrial Employment, National Facility Holidays Act, and the Labour Welfare Fund Act developed by the respective state governments. And in social security, we have Employees Provident Fund, we have got Employees State Insurance Scheme, then Payment of Gratuity Act, and Workmen Compensation Act, and Maternity Benefit Act. Then the trade unions and employee relations, we have Industrial Disputes Act, the Trade Union Act, and the Industrial Employment Standing Orders Act. Now here, these legislations can be broadly categorized as follows. The labor laws enacted by the central government, where the central government has the sole responsibility for enforcement. This is one type of legislation. I will give certain examples. Labor legislation enacted by the central government and enforced both by central and state governments. This is another category of labor legislations. Labor laws enacted by central government and enforced by the state governments. And labor laws enacted and enforced by the various state governments which apply to respective states. I will give certain examples. It is not exhaustive, but only indicative examples I will give you. For instance, labor laws enacted by the central government, which central government alone has the sole responsibility for enforcement. For instance, if you take the ESI Act, that is Employee State Insurance Act, and the Employee Provident Fund and Business Procedures Act 1952, the state has no responsibility in enforcement, but it is only the central government. Then labor laws enacted by the central government and enforced by both central and state government. Examples are from the Child Labor Prohibition Act, Building and Construction Workers Act, the Contract Labor Regulation and Abolition Act 1970. These are a few examples. The labor laws enacted by central government and enforced by state governments is Trade Union Act and the Factories Act. And the labor laws enacted and enforced by various state governments which apply to respective states alone is, for examples, are the Labour Welfare Fund Act and the National Festival Holidays Act. Broadly, these are only a few listed examples. Of course, there are a number of labor laws which fall into these brackets. Now, let us go and examine how far these labor legislations have connectivity with the Constitution of India. Because the Constitution of India is the backbone of providing equal opportunity and fundamental rights and direct the principles of state policy to direct the state's government to enact such regulations, such laws, to ensure that social justice is given to everybody. Now, this is a very important aspect, how far the labor legislations have got the backing of the Constitution of India. In fact, the role of state government is extremely important. Before they enact any law or enforce any law, they have to ensure that whatever the action they take, whatever action they do, it should fall in line with the Constitution of India. The constitutional framework and fundamental rights are guaranteed in the Constitution. It is a responsibility of everyone, including the corporates or the state government or the central government or the authorities, to ensure this is in. Of course, it all aims at the philosophy of social justice. The aims and objectives of the International Labour Organization and its role in pursuit of social justice is extremely important. In fact, the ILO has convened and passed several conventions across the globe, and particularly applicable to India also, and the Indian government also adopts these conventions and they have converted into different legislations so that the international labour conventions are implemented in spirit. And the role of law in industrial relations, that's important. We'll try to examine it. Now here, the government of India therefore enacted a series of legislations to protect the working class from exploitation, to bring about improvement in their working and living conditions. Examples are, these are a few examples. Industrial Disputes Act or ESI Act, Factories Act, Minimum Wages Act were enacted. The goals set out in the Constitution have a bearing on industrial relations and adjudication principles. The constitutional framework of Indian Constitution guarantees fundamental rights to citizens and has laid down certain directive principles of state policy for achievement of the social order based on justice. Equality of opportunity to all citizens in matters of employment is guaranteed. then trafficking in human beings, forced labor, employment of chain labor in factories, mines and other hazardous vocations are totally prohibited because it, number one, it is aimed at elimination and ensures social justice and avoids exploitations. If you see Article 39 of the Constitution of India, it accepts the basic philosophy of idealistic socialism and provides a motivation force to the directive principles of in laying down the state shall direct this policy towards equal pay for men and women. Arising out of this, now we have today Equal Remuneration Act, and to say that there cannot be any discrimination and discrimination between the various genders in society. Article 41 lays down the state shall within limits economic capacity and development provide right to work, right to education, right to public assistance in case of unemployment, old age and sickness and disablement. So it is a responsibility of the state government to take care of these proper steps to ensure the Article 49 is implemented in spirit. Then Article 42 also enjoins the state government make provision for securing just and humane conditions of work and for maternity benefit. For instance, now the Factories Act and even the Maternity Benefit Act take care of these aspects which is provided in Article 42 in providing health, safety and welfare and employment of young women, young persons and women, hours of work for adult workers, holidays and leave with wages, etc. And similarly, Contract Labour Abolition Act was passed to protect the contract labour from exploitations. Then Article 43 enjoins the state to assure living wage. Conditions of work ensuring decent standard of life and full enjoyment of leisure and social and cultural opportunities. In these actions, we can always say that the Minimum Wages Act provides for fixation of minimum wages by the government for workers. Then Employee State Insurance Act, which include benefit like sickness, extended sickness, then maternity benefit, disablement benefit, funeral and medical benefits. Employees Provident Fund Act and Maternity Benefit Act are also equal social security measures. Then Apprenticeship Act also is implemented institutional training, on the job training for people who are unemployed youth, so that they get an opportunity to be in the employment field after rigorous on the job training in various industries. Now here it is gratifying to note that apart from fundamental rights, Indian Constitution embeds within itself the directive principles of state policy. Here, the functions and duties of state as contained directly have been given rise to the concept of social justice. Here, the philosophy of social and economic political justice have been given in place of private constitution as well as in the objectives of the ILO. We will go into details. I will just share with you. Now, for instance, now we see that Article 136 of the Constitution provides the Supreme Court can intervene in any manner at any point of any judgment or decree or determination or sentence or may causes or matter passed by made by any court of law which is not in line with the Constitution of India. In the case of Bharat Bank versus employees Bharat Bank in 1950, the Justice Khani was of opinion that the wording of the Article 3 was wide enough to give jurisdiction to the court to enter in such an application. Although having regard to the nature of functions of the tribunals, the court would reluctantly entertain such an application. It means that he said that it has got vast powers in Article 139 to ensure proper justice is given to the parties. In the case of Bengal Chemical and Pharmaceutical Works, the Supreme Court laid down the principle that it could exercise its discretionary duty only in cases of violation of principles of financial justice. Here it has got vast powers. The Supreme Court has said very clearly that the moment they see any deviation from the principles of natural justice or social justice away from the constitutional result, the Supreme Court has to intervene, will intervene and set the matter in motion. Now here, in this case, question came right to strike over the constitutional validity. In the case of All India Bank Employees Union or National Tribunal in 1962 itself held that the rights guaranteed by Article 19(1) of the Constitution of India does not carry, it carries only the fundamental right to form a union, but it does not carry a right to go on strike, hurting or causing any inconvenience or to anyone in terms of law and order of the society. In the case of B.R. Singh versus Union of India, Justice Amuni was said that right to strike cannot be equated to that of a fundamental right. So fundamental right is different and right to strike is different. But in the case of Communist Party versus Bharat Kumar versus in 1998, the Supreme Court adjudicating the legality of strike held that fundamental rights of people as a whole cannot be subordinate to claim for individual or a section of the people. The appellate further opined that strike as a weapon in any field does more harm than any justice. So here also the courts intervene. Though the union says it's a fundamental right to go on strike, the court says it's not your fundamental right, but you have got a legal right provided you follow all the principles of law before going on a strike. In the case of Rajaram versus state of Tamil Nadu, here probably you may be aware that in the year 2000s, the Tamil Nadu government terminated the services of many government employees because they went on mass strike. Then the apex court has said that the judgment of previous and Commercial Prasad of State of Bank upheld, saying that there exists no fundamental right to strike, and is there a case on that. Now, if you look at these slides, I have made an attempt to compare the fundamental rights and the directive principles of state policy. On the right side of the slide, you will find the fundamental rights, that is freedom of speech, expression, assemble peacefully, form associations, unions, free movement, and practice any profession. Then equality before law, prohibition of discrimination, equality of opportunity, abolition of untouchability, right to constitutional committees, and cultural and educational rights. These are the fundamental rights guaranteed in the Constitution. On the left side of the slide, you will find the directive principles of state policy. Here it is the responsibility of the state government to ensure that these principles are embedded in their system for implementation. It can be by acts, it can be by rules, it can be by regulations, they can do this. Here, men and women have a right equal, adequate means of livelihood, equal pay for equal work, health and strength of workers, tender-age children not abused, not forced by economic necessity to enter avocations. Then equal justice and free legal aid. This is also one of the responsibility of the state government. Then right to work, education and public assistance. The state government is bound to make certain rules and regulations in this manner. Then provision for just and humane conditions of work and monetary relief. Then living wage for workers. Here we have got the Minimum Wages Act, which takes care of the entire thing. Then participation of workers in management, then uniform civil code for the citizens. These are the important things. Now here, let us say how the Constitution really have worked the corporate in many several cases, how it has come. Let us try to, I will just take you through some illustrative cases. It's not exhaustive. In fact, if you go through the chapters, it has got any number of cases on this matter. But I have picked up a few case laws which is of importance to emphasize that the articles of the Constitution of India, how it has been protected by these courts. In the case of Ranveer Singh versus Union of India, Supreme Court held that although the principles of equal pay, equal work is not expressly declared in Constitution to be a fundamental right, but it is certainly a fundamental goal under Article 14, 16 and 39C of the Constitution. So he said that equal favor, equal work is a must, it has to be taken care of. In one case, a daily rated casual labor versus India, the Supreme Court came very heavily on this. the classification of employees into regular employees and casual workers for the purpose of payment of less minimum wages is violative of Article 14 and 16 of the Constitution. Because many times it happens with a view to to save the money, with a view to save the money. There is a discrimination between the pay in terms of regular and casual employees, and he said this is violative of Articles 14 and 16 of the Constitution. Then in the case of Damayanti versus Union of India, Supreme Court has held that right to form an association in court necessity implies the person forming association have also the right to continue to be associated with only those whom they voluntarily admit in the association. So this is also an important issue. Then the Madras High Court, as you know, that in a very, very recent case of 2001 has happened. It held that Section 66 of the Factories Act is ultra vires, as it violates the fundamental rights guaranteed in the Constitution of India, in the case of Vasanta versus Union of India and others. Here what happened, the women, as you know, in Section 66, it prohibits the engagement of women in the night shift. So working night shift is a choice, is a fundamental right of an individual, because under the articles is guaranteed that you have a right to work. So this question came up before the High Court, and the Madras High Court had clearly struck down this section as unconstitutional. He said no such restrictions can be put for the women who are willing to work in the night shifts. Now, of course, the central government is now contemplating to amend this Section 36 accordingly on account of this judgment of the High Court. But here, in the case of Cinema Workers Union versus Secretary in the Karnataka High Court has held that non-fixation of minimum wages of cinema workers for the last 13 years is violation of Constitution of India. Then, in Ranbakshi versus State of West Bengal, he said that unreasonable clauses in a contract with the employee will be violative of Constitution of India. Then important case here is that in case of DK Yadav and MA Industries, the Supreme Court held that the right to life enshrined in the Article 21 includes right to livelihood, and therefore termination of a service of worker without giving him a reasonable opportunity of hearing is unjust, arbitrary and illegal. In fact, this case is a landmark judgment. Even today it holds good. In other words, no employee can be terminated without giving a reasonable opportunity of hearing, that is, conducting a full-fledged inquiry into that and then only take further actions. So, in other words, arbitrary termination of service is violative of Article 21. Even today it holds good. Then very recently, in the case of Vishaka versus State of Rajasthan, you may know that the Supreme Court has held that sexual harassment of women at workplaces amounts to violation of fundamental rights as guaranteed under the Constitution of India. The Supreme Court came very heavily in this case. Of course, we will deal with this case when I deal with the particular chapter. In state of Maharashtra, also Munibai Court has considerably widened the scope of right to free legal aid. He said that the right to free legal aid and speedy trial are guaranteed and fundamental rights in Article 21, and Article 31A provides equal justice and free legal aid. It means justice according to law. So it means that everybody is entitled for free legal aid in all the cases. Then Supreme Court also has very clearly held that payment of wages lower than the minimum wages is again a violation of such Article 23. In Dina versus Union of India, in fact, the laborers taken from prisoners were without paying proper remuneration or amounted to forced labor. Here what happened, the prisoners were made to work, but they were paid less remuneration as compared to other categories of employment. Then the Supreme Court came very heavily on this. He said this is violative of Article 23 of the Constitution of India. Hence the prisoners are entitled to payment of reasonable wages for the work taken from them, and the court is in a duty to enforce their claim. In the case of Mehta versus the state of Tamil Nadu, the Supreme Court has held that children below the age of 14 years cannot be employed in hazardous industries. He said that if they are subjected to humiliations in rights of millions of workers working illegally in public and private sectors, it must be abolished because this is against the fundamental rights guaranteed. So I try to give a brief introduction on the liberalizations, on the background of it, the principles behind it, and the constitution protection for labor laws in this matter. In fact, the citations I have given you is just illustrative, is only indicative, and we can go through a lot of cases, n number of cases in this area. So, thank you very much.